Welcome to Public Occurrences. I'm Jason Beats. This episode is part 2 of my interview with David Frakt, a former defense attorney at Guantanamo. In this episode, we discuss the jurisdictional issues involved in prosecuting terrorism cases in military commissions and federal courts.
From Manhattan, Kansas, it's time for Public Occurrences with Jason Beats, the online public affairs show with in-depth world news and analysis you won't find anywhere else.
Do the commissions only have jurisdiction over crimes committed in the theater of war?
Well, the jurisdiction is not defined geographically. It's not limited geographically. It is an element of the crime that the government has to prove that it took place in the context of an armed conflict. But, at the time, and we have spoken about, even though the term is now out of favor, a global war on terrorism. And generally the U.S. government position is that one cannot avoid criminal liability simply by conducting hostile acts outside of an active theater of war.
There is a case against Mahid Khan for conduct in Pakistan, and then there's al-Darbi, who had to deal with an attack on a French oil vessel. But that was an attack based in Yemen. So the fact that didn't happen like in Afghanistan or Iraq during those wars isn't an issue?
Well, and al-Nashiri is also charged in association with that attack on the French ship, the MV Limburg. Al-Darbi had charges sworn against him, but they have not been referred to trial, so he's not currently facing trial. And Majid Khan, pled guilty as part of a plea bargain, so he's not going to be in a position to appeal those issues, such as, I was in Pakistan. But if the coal bombing, which was planned and executed in Yemen, is considered part of the ongoing armed conflict with Al-Qaeda as part of a global jihad that started in the mid to late 90s, then I don't see why the attack on the French ship in international waters would be any different.
In October 2012, former Guantanamo prisoner Salim Hamdan's conviction by a military commission was overturned by the D.C. Court of Appeals. Salim Hamdan was a member of Al-Qaeda who was a driver for Osama bin Laden. The crime he was convicted of, material support for terrorism, was added to the list of war crimes triable by military commissions by Congress in 2006. The court ruled that for actions committed before 2006, military commissions can only try prisoners for crimes that were already war crimes, such as internationally recognized war crimes, as we have discussed, including killing civilians, killing wounded soldiers who were incapacitated, and using chemical weapons. Many of the prisoners previously convicted in the military commission system were only guilty of crimes like material support for terrorism that were not triable by military commissions during the time they committed the actions that served as the basis for their convictions. What are your thoughts on this ruling?
All right, well, first of all, there's a follow-up to that. That's not the end of the story. So Salim Hamdan was convicted of one and only one offense, which was material support to terrorism. I mentioned earlier that there have been 2 trials at Guantanamo. The other involved my client, Ali Hamza al-Balul. By the way, Mr. al-Balul directed me not to represent him and not to put on any defense on his behalf. So,
we will talk more about Bahlul's case a little bit later as well, but you're more than welcome to elaborate.
Well, it's directly relevant to this issue of appeal because he was convicted of material support to terrorism, solicitation to commit terrorism, and conspiracy. And he was appointed appellate counsel, and his counsel also appealed his conviction. despite the fact that I had not put on any defense at his request. After the Hamdan decision by the D.C. Circuit, Al-Balul's defense attorney said, well, this ruling is binding on Al-Balul, therefore his conviction should also be thrown out, because none of the three things that he was convicted of, material support, solicitation, and conspiracy, were war crimes at the time that he was alleged to have committed them. That's all pre-2006. In fact, Al-Balul was one of the first people brought to Guantanamo in January 2002. So he's been there for 12 years now. But his acts were all late 2001 and before. All right. Now, the D.C. Circuit, a panel of 3 judges of the D.C. Circuit Court of Appeals, agreed. In fact, the U.S. government agreed that under the ruling of Hamdan, that the conviction would have to be vacated, thrown out. And so his conviction was also thrown out. And then, interestingly, the federal government appealed. They asked for the entire D.C. Circuit to reconsider the case. It's called an en banc hearing. So instead of the 3-judge panel, it would be all of the active judges on the D.C. Circuit. And the D.C. Circuit agreed. And part of the reason they agreed is because the government emphasized that every single conviction at Guantanamo to date, and there have been 7, 5 by guilty plea, 2 by trial, all 7 were convicted of material support to terrorism. Some that was the only offense. Some were convicted also of conspiracy. But generally, if that ruling stands, then all the convictions are invalid and all will have to be vacated. From David Hicks.
Okay, so on the ones that were convicted of other things in addition to those things, would those convictions be overturned? Can you overturn just part of the ruling?
They were all convicted of only those offenses.
Right.
There hasn't been any extra things other than material support, conspiracy, with the exception of Majid Khan. He pled guilty to some other things. If part of the conviction is overturned, then the sentence has to be reconsidered. So everything would be in jeopardy. Everything would be up in the air. The majority of those guilty pleas would have to be thrown out, even though some of those people have already been released as part of the terms of their pretrial agreement. But also, the ruling threw into doubt who else could be charged and what they could be charged with. For example, you mentioned Al-Darbi. He had charges sworn against him. One of the reasons that they've been on hold for a couple of years is because we're waiting to find out what charges are valid under the law. So the D.C. Circuit heard this appeal on September 29th or 30th of 2013, and we are awaiting that ruling.
And when do you think that'll happen?
It could be any day.
Okay.
Because it's been 4 months. Typically these are 4 to 6 months. So it could be any day that we get a ruling. Now the government has said if they lose, they will probably appeal to the Supreme Court. Certainly, if Al-Balul loses, he will appeal to the Supreme Court. So I don't think, but they may not hear it. It'll be interesting to see. But right now, everything is in limbo. It's up in the air. So what that has meant, and by the way, I agree wholeheartedly with the D.C. Circuit decision. I have said all along, including in congressional testimony that I gave back in 2008, that material support to terrorism, conspiracy were not internationally recognized war crimes, that they should be removed from the statute, that they should focus only on legitimate war crimes. But the fact of the matter is there are very few legitimate war crimes committed. we have these a couple attacks on civilians. We have a couple of perfidious attacks. But one of the reasons that the number of defendants expected to face trial by military commission has steadily dwindled over the years from a high of about 80 to now maybe 15 to 20 is that as the crimes were limited to actual war crimes, they realized they only had a small group of people that they could actually try. And that could be further limited if there was a determination that there really wasn't a war going on until 9/11, that will further limit the number of cases that could be tried.
This decision contributed to creating what I refer to as the Hamdan Curse. Every year since 2011, Congress has passed an amendment to a military spending bill that prevents the president from transporting Guantanamo prisoners to the United States to be tried in civilian courts. The president also has the ability to imprison individuals accused of being part of Al-Qaeda or the Taliban until the end of hostilities in the War on Terror, a war with no apparent end. This power is known as indefinite detention. Indefinite detention, the prohibition on trying Guantanamo prisoners in civilian courts, and the confirmed lack of jurisdiction of military commissions over crimes such as material support for terrorism, has resulted in a number of prisoners who were recommended for prosecution being held in indefinite detention without receiving any trial at all. How, if it's possible, can the Hamdan Curse be solved?
All right, well, you've hit on a number of important issues. Certainly it is absolutely true that Congress has done everything possible to tie the president's hands, to make it impossible for him to close Guantanamo, to make it as difficult as possible for him to reduce the Guantanamo population by placing legislative restrictions on his ability to transfer detainees. So not only have they restricted him from bringing detainees to the United States to face trial in federal court, they've prohibited transfer to the U.S. for any reason, and they have prohibited or limited transfer home or to third countries unless a very stringent set of security restrictions could be met. And that during the Bush years, it should be emphasized, there were no restrictions at all on President Bush's ability to release Guantanamo detainees. So he released on average 75 detainees a year, whereas President Obama has only released about 75 to 80 during his first 5 years because they've made it so difficult. Now, so who is left at Guantanamo and how can they, what's to be done about them?
Oh, I guess before you go on, just one point that I do want to make. The limitations, as you very aptly described them, on transferring the prisoners back home, back to where they're from, Egypt or Yemen, etc., those have finally been dropped by Congress in the last NDAA, but they were in place for several years.
Right. Yes, there was a recent change that gives greater discretion to the Secretary of Defense to repatriate some detainees who have been cleared for release or cleared for transfer. And there are scores of them, about 80, that have been cleared for years and have been held in limbo. So that's very troubling aspect of this. Now, you talked about indefinite detention. I think the Obama administration would partially differ in the sense that they said this is law of war detention and it is tied to the duration of the conflict. But your point that how do we know when this conflict is over and will it ever be over is well taken. Now, it may be that there's two separate conflicts that we have to consider. One, a conflict against the Taliban, which may come to a conclusion when we end combat operations in Afghanistan later this year, and then an ongoing armed conflict against Al-Qaeda and its affiliates. So So we may be forced to release those who are associated with Taliban and not Al Qaeda, because one, armed conflict will come to a close. But there appears to be a category of approximately 49, 50 individuals that the president has said these people are too dangerous to release, but can't be tried. And so one question is, why can't they be tried? How do we know they are so dangerous, and why can't they be tried? If they're so dangerous, they must have committed some kind of crime, or that would be the thinking. Well, there's a couple of reasons why we know that they can't be tried. The main reason is that the evidence that we have gathered against these individuals was obtained through illegal means that would not be admissible in a federal court or, frankly, in a military commission, because that evidence was obtained through torture or highly, at the least, highly coercive interrogation. And so there are people that we have a fairly high degree of confidence that they are dangerous terrorists and have continued to pledge their allegiance to Al Qaeda, yet we can't actually prove any past criminal conduct with admissible evidence in a court of law. Some of that evidence may also have, in order to present it, we would have to compromise some of our national security methods or sources, or at least that's a claim that's been made by the administration, and they're not willing to do that. And in other cases, the crimes are really terrorism crimes that may not be triable in a military commission, but because we've now held these people for 10, 11, 12 years, it may not be possible to try them in federal court, even if those restrictions were lifted. So we do have a problem with this group of people that we really have no intent to release, yet there's nothing that we can do with them. We can't put them on trial. And this is something that's very troubling to people who care about human rights.
But there was one person that I finally found scouring through all of the biographies, and that was al-Hadi al-Iraqi, who is actually charged with actual war crimes during an actual war in a theater of war in Afghanistan. And so out of all of the you brought up the missions of that, before the U.S. was at war. And so when you apply that requirement, out of all of the people at Guantanamo, I found one person who could actually be convicted reasonably of war crimes, or at least the charges make sense.
Right. Yeah, I think there's a small handful of people whose crimes or alleged crimes were committed either in Afghanistan or close to it. Another interesting question is, there's a couple of Indonesians and Malaysians who were involved in bombings in Bali, Indonesia, and that was post 9/11, and they were part of affiliated networks of Al Qaeda. So there, again, was it part of an ongoing armed conflict, or were those separate civilian or terrorist attacks? Clearly, it was on civilian targets. But I think you're right. There's a very small number of situations where someone in a universally agreed armed conflict, which is what we've had in Afghanistan since we invaded in November 2001, that there was actually war crimes committed there. So yes, it's a very, very small number.
We talked about the jurisdictional issues at length in the military commissions. The alternative venue for trying the Guantanamo prisoners would be federal courts. Are there any jurisdictional issues with regards to using civilian courts to try those Guantanamo prisoners? For instance, could you have tried Hamdan in a federal court for material support for terrorism, or the many people like Hamdan who are accused of similar things?
Well, that's an interesting question. One suggestion that has been raised is that because we've held these so long and in such harsh conditions, that would create a speedy trial problem, that if we now attempted to bring them to trial in federal court, that they could seek to have the charges dismissed for failure to bring the case in a speedy fashion. Now, I should note that there was one detainee who was transferred from Guantanamo to the United States to be tried in federal court. His name was Ahmed Gailani. Now, Gailani was involved in the attacks on the U.S. Embassy in Tanzania and Kenya, and back in 98, 99 time frame. And he was indicted by a federal grand jury in New York back in 99, 2000, along with several others. But of course, at that time, he was not in custody. So there were a couple of trials of people who were in custody who were related to those terrorist attacks, and they were convicted, but Gailani remained at large. When he was captured in, 2002, 2003, rather than turning him over to the U.S. Marshals and bringing him to New York for trial, where he was already under indictment, he was brought to a CIA secret ghost prison where he was presumably tortured. Later, he was brought to Guantanamo, and he was charged in the military commissions with the exact same crimes that he was already indicted for in New York. Now, when President Obama was running for office back in 2008, he expressed a desire to stop the military commissions, close Guantanamo, and a preference for federal courts. So one of the first things he did when he assumed office was to order that Gailani be transferred to New York to face the indictment that had been in place for many years, and that military commission charges were dropped. Gailani was put on trial, and he was convicted, and he got a life sentence in federal court. One of the issues that he raised was the speedy trial issue, and the fact that several years had passed and he was in U.S. custody, including in CIA ghost prisons, and that should preclude the U.S. from now trying him at this late stage. And that issue, that the motion was denied by the court, and also on appeal. So, at least in his case, that delay from 2003 to 2009 was not considered significant enough to prevent him from being tried. But another 5 years have now passed, and I'm not certain that another federal court would rule the same way. So it is a potential problem if we were to try to put someone in federal court now. But it's difficult to say how it would come out. Another thing, the 9/11 defendants, of course, President Obama announced his intention, or Attorney General Holder announced the intention to try them in New York. They, in fact, were indicted in New York, but due to local opposition, the plan was dropped, and then Congress imposed the restrictions on transfer to prevent Khalid Sheikh Mohammed and the other alleged co-conspirators from being tried in federal court. And so the only option that currently exists is the military commissions.
With federal courts, there are some terrorist attacks, like the attack on the French ship, for instance, or even the Bali bombings in Indonesia that you brought up. Can we apply universal jurisdiction? Can we try people for crimes that were not committed against the United States in federal court that are generally recognized as violating international law?
Yeah, absolutely. Yeah, there's no problem trying someone for a crime of international terrorism, international piracy, clear violations of the law of international law of war. for all of these, there is a principle of universal jurisdiction. I mean, typically you would want the prosecuting forum to have some connection with the crime, some reason to be interested in prosecuting it, but that's not actually a requirement. So yes, it's not a problem. And I would note that a couple of terrorists that we've captured recently, for example, this guy Al Libby in Libya.
And that was specifically a Nassau Libby, because there are a lot of Al Libbys. Al Libby means from Libya, and it's so complicated keeping all of them straight. But yeah, go on.
This gentleman was captured just a few months ago, and he was sort of kidnapped or taken to a U.S. Navy ship that was.
He was rendered. Yes.
Well, right. Rendered. You know, there was a lot of rendition going on during the Bush administration when we were sending people to third countries. We were outsourcing our torture to places like Morocco and Egypt. We didn't do that.
Right.
We didn't torture him. We brought him to a ship, we questioned him, and then we brought him fairly quickly to New York, where he was arraigned, on federal charges. So clearly we can do that even for pretty old acts of terrorism. I believe he was suspected of involvement with Lockerbie bombing or some other attacks many years ago. And if someone is a fugitive and at large, the mere fact that a lot of time has passed is not a problem.
This episode is part 2 of my 4-part interview with David Frakt, a former defense attorney at Guantanamo. In the next episode, we discuss the case against his former client, Mohammed Jawad, a child soldier prosecuted for war crimes. We also discuss the other juveniles who have been imprisoned at Guantanamo. See you there.